Good afternoon to everyone and greetings to the candidate. Advisory group of experts in its full composition will conduct interview now with the candidate for the position of a judge of the Constitutional Court of Ukraine, Mr. Tsymbalistyi Taras, the prosecutor of the Office of the Prosecutor General, who has been admitted to the competitive selection process by the Verkhovna Rada of Ukraine. The interview will be facilitated by the Secretary of Advisory Group of Experts, Mr. Yaroslav Romaniuk, who will now take the floor. Please, Mr. Secretary.
Thank you, Mr. Chairman. Good afternoon, Mr. Taras Olehovich. Please help with the headset to the candidate. Good afternoon, dear Taras Olehovich. I will talk in Ukrainian. My greetings to the public for the live streaming of the interview. Today for the interview, all 6 members of the AGE are present here. The chairman of the AGE, Alex Zaller, who will be present online, and offline we have in the hall the following AGE members: Miss Hanna Sukhotska, Miss Maureen O'Connor, Miss Natalia Kuznetsova, Miss Oksana Vasilchenko. Also, the deputies of the AGE members are also present: Mr. Thomas Griffith, Mr. Richard Barak, Mr. Marek Zubik, Mr. Vasil Shakun, Mr. Volodymyr Kuzmenko, and me, the AGE Secretary, Yaroslav Romaniuk. Mr. Taras Olehovich, we have accumulated sufficient amount of the information. We are really grateful for your communication with the Secretariat of the AGE and provision of the answers. Today we want just to clarify some answers to the questions, and we would like to give you an opportunity to debunk or clarify any doubts regarding your high moral qualities that are needed for the candidate for the position of a judge of the Constitutional Court of Ukraine. Let me draw your attention to the fact that the candidate cannot provide information, documents, and other materials during the interview if the advisory group requested their provisions before and the candidate has not provided them within the period set, or if the candidate could have provided them on his initiative before. However, the advisory group of experts may make an exception if it concludes that such an exception is justified. I also want to inform you that the interview is being recorded and broadcast live on the resources of the advisory group of experts and the website of the Constitutional Court of Ukraine. Therefore, I urge members of the advisory group of experts and the candidate to restrict the use of sensitive data and information with limited access during the live broadcast. If discussion on such sensitive data is needed, we will stop the broadcasting and will discuss it here in private. I would like to emphasize that the duration of the interview is approximately 1 hour. Please be laconic and concise in your answers, as the time limit for the answering questions is up to 3 minutes for each question. International experts of the AGE do not speak Ukrainian, so you have possibility to use the headset with simultaneous interpretation into Ukrainian. Blue light means Ukrainian simultaneous translation. Please use the headset if needed. At the end of the interview, before wrapping up the interview, you will be given an opportunity to pronounce your brief closing statement up to 5 minutes. Now I pass the floor Two members of the AGE reporters on your case, Ms. Sukhotska and Ms. Vasilchenko. Please, the floor to rapporteurs.
Thank you. I will ask you the first question. In your response to the inquiry made by the advisory group of experts regarding the reasons for your failure to indicate in the 2016 declarations the information about your joint ownership of a residential building with an area of 96.2 square meters, located at Ivano-Frankivsk region, Rohatyn Rayon, the village of Polik, you stated that at the time of filling your declarations for 2016, you were not aware of your parents' registration of ownership of the said residential building. You found out that according to the certificate of ownership of this house, you own only 1/6 of it much later, namely in early 2020, but we are discussing now on year 2016. At the same time, the certificate of ownership of this property shows that you have been a co-owner of the said house since 1st of February 2001. Is a differences in date are very, how to say, right. That is you, as a professional lawyer, the declarant and the son of the individuals who live in this house, and according to your own words, the person who registered ownership of this property claimed that you did not know and could not have known that you have been a co-owner of this house for almost 20 years. Do you understand, you have to take it into account, that these circumstances can give a rise to reasonable doubt concerning your honesty or good faith? How you can explain these discrepancies in these dates?
Thank you. Ms. Hanna, to answer your question, I would like to say and to confirm that, as I have stated in my explanation for the question of the AGE, I learned about these circumstances only at the beginning of 2020. I will explain myself. In 2000, my grandfather died, and my granddad constructed this house. So he was the owner of this household. The only heir was my mother. The corresponding certificates were given to her in the order foreseen by the law, and she was the only one who dealt with these documents. For all of us, it was obvious that the mother, my mother, was the only heir, and in our family, it wasn't acceptable, and it wasn't a tradition to pretend for something. It was like general consensus that the mother is the heir, she will inherit it, and she had all these documents. Nobody asked about who is indicated in these documents. So by default, we understood that my mother inherited the house. And then in the year 2020, when I was at my parents' and looking through different documents regarding education of my parents, correspondence, some old photos, etc., accidentally I found out the document about the ownership, and I was really surprised to find out that all people who lived in this house were written in this document. So my grandfather, my grandmother, and even another grandmother that had died before in 1992. My parents, me and my sister. And I own 1/6 of it, and in the closest declaration I indicated it. It was my integral behavior. I hadn't known about it before, And given the traditions, our family traditions, I never asked my mother about the grounds, about the parts, etc. So it was general exception that my mother inherited this house.
So you confirm now that for almost 20 years you didn't know that you were co-owner of the house, because you said now that only in 2020 you accidentally, as you said, you found document that was clearly, how to say, written that all inhabitants of the house are co-owner, and till 2020 you had no knowledge about it.
Правильно.
Yes, it is correct.
Lawyer looked at the document, because when your grandfather died and then grandmother, you never try to look at the document. How is the situation? How is the status of the house, of your, how to say, rights in this house?
I have never assumed that I could have some ownership rights, because the owner of this house was my grandfather, and after his death, my mother inherited all the ownership. Not only the house, there were also the ownership right for some investments, for land plots and terrains. So it was clear to us that our mother, my mother, was the only heir, and the status about the ownership for this house we have never asked, because we didn't think that it could be plausible. So nobody pretended, nobody wanted to have anything from it, and we didn't want to violate the silent consensus. Me too. I wasn't a subject of declaration. My first declaration was submitted in 2017 for 2016. And after it, I found out, as I have already stated, it happened in early 2020.
You can say unclear situation for us, how it could be possible, because your mother became inherited the house by law. How it happens, and what was the situation that finally you were also included to the certificate? Who did it? How it has happened that you were included in the certificate as a co-owner just in 2001? You never had no knowledge about it.
Я можу
I can explain it like this. It is obvious that some documents as technical passports, they were produced and issued when my grandfather was alive, as I can assume. And the people who lived in this house were written in the document, and who, based on the joint ownership, were put into these documents. But I didn't know about it. I didn't know about it.
Реєстровані в цьому будинку.
в який час, вибачте, я прослухав. Чи я був зареєстрований в цьому будинку?
На момент
So were you registered in this house when your granddad died? No. I entered the university in 1992. So when I left this house in 1992, I have never returned, because at first 5 years I studied at the university, and then my career also was in other cities. So at the period when this document was produced in 2001, and when there was termination of the farm association, you see, I entered the university in 1992, and then I re-registered in Lviv for the educational period. So when this farm agency was terminated, you were registered there. In 1992, I changed my registration. Thank you, it's clear.
Not so clear, but we can pass to the second question. The second question involves also some doubts. As you have informed the advisory group of experts, on 24th July 22, you borrowed from the citizen of Ukraine, Simanchenko, 120 Ukrainian hryvnia, and on July the same year, 22, you got a loan from the citizen of Ukraine, Uliaszkiewicz, for the amount of 120 hryvnia, Ukrainian hryvnia. You explain that Simanchenko is your colleague at work, while Uliaszkiewicz is your sister, and those loan agreements are interest-free. Explain why you borrowed the above amounts of Ukrainian hryvnia 120 from each of these persons separately and not the total amount from any of them. Don't you think that your behavior looks like manipulating the requirements of the current legislation in terms of trying to avoid the obligation to file declarations of significant changes in property status, since as 2022, the loan amounts of 120 Ukrainian hryvnia each received by you were several thousand less than the amount subject to mandatory declarations from 124 Ukrainian hryvnia upwards. Yes, how was your calculation? What was the reason that you decided to do in such a way?
Thank you, Ms. Hanna. Answering your question, I would like to mention and to explain the following. Yes, on these dates, I obtained sums of money from people indicated by you, and there was a goal. The goal was I planned to make a sale purchase agreement for an apartment, and funds that we possessed were insufficient for this transaction. It was about the purchase the apartment as of 2nd August of the same year. That's why we wanted to involve the additional funds. We decided to take these funds from people who could borrow them or from bank institutions. That's why Uliaszkiewicz Mariana, my sister, informed me that she would like to give me more funds, but it was the only amount that she could give me. She didn't possess any more money. Analogically for Simanchenko, according to his living conditions, he couldn't permit himself to lend me bigger sum. And also we took some funds from banking institutions, but I won't mention it here. Maybe in some other questions I will talk about it. So these sums were not manipulated. These were the sums that people could lend to me. I explained what was my goal, why I need this money. The goal was stated transparently and clearly, and these sums were formed like this.
I think that this question for the moment I have no more doubts. The third question. According to the data of your declarations, you are the owner of an asset under reconstruction, residential building with an area of 259.8 square meters in the city of Ternopil in Projektna Katynowa. The construction passport was issued on 30 of May 2012. The above construction is in progress, is located on a land plot with cadastral number, you know which one, I don't really read it, owned by you under the purchase and sale agreement dated 16 of August 2011. In your response to the inquiry made by the advisory group, you informed us that construction works related to this building were launched on 11 July 2012 and are still ongoing, and that the building's condition does not meet the requirements for its commissioning. According to your assessment, the percentage of completion of this building may be approximately 70 to 80%. According to the photographs of the property you have provided, the building is quite large and monumental. The house had been under permanent construction already for almost 12 years, or even more, yes, because we're in 2024. According to the information the experts of the advisory group have, you and your wife had a stable fixed income both before the beginning of construction and still have it. Explain whether an outside observer may get the impression that such a long period without putting the said residential buildings into operation is related to the avoidance of taxation of this property, as the residential property exceeding the minimum not taxable area over 120 quadrat meter. Please.
Thank you, Ms. Hanna. The circumstances that you mentioned about the construction, they are real. We started construction in 2012. The construction of this house, it was our dream, it was our desire, but it wasn't the only goal, because we lived in the central part of the city, because the house is in the outskirts. It's on the ex-village that was then joined to the city of Ternopil. So our children attended school, it was comfortable for us, and together with the circumstances that we didn't have funds to give us possibility to finish the construction, so we had the desire but we didn't have opportunity. That's why we did it stage by stage. And during all these many years, we made further and further steps, moving to our dream, to the accomplishing of the construction. But we haven't managed it because in the year 2000, as there was reforms of the prosecution office and I took part in a selection procedure, I won this competition and my life very dramatically changed. I moved to Kiev and my family after it moved to Kiev. That's why construction of this house remained at the background. At that period, I mean 2020, summer 2020, when I left for Kiev, this house remained in the state very far from the commissioning, and in the state that still doesn't give possibility to live even in part of this house. I sent you different photos from external, internal state, and you can see what is the state of this house. So we couldn't talk about the commissioning. It's not only about some external or internal characteristics, but there are no communications, no other grounds to commission it. Because to commission house, you can commission a house if it corresponds to the requirements. And now at this stage, there are no grounds for its commissioning. So it hasn't been finished. There are a lot of construction works to do.
And what do you think? What are your plans with this house? Because would you like to finish it on? Because as you explain us, you change your place. Now you are living in different situations, different conditions. What is the situation with the house? Yes, you would like to keep it. You would like to go to the end with the construction, because in such a situation the house will be going to further destroyed. Yes, instead of being a real house. How is your idea to keep such a?
Дякую, шановна.
Thank you, Ms. Hanna, for your question. Your question is really very plausible, because for us there is a dilemma. From one point of view, yes, it stands there and it is not finished. Maybe it's not ruined so much because it is a new house. It is on the upper place. There are no underground water. It is in a very dry place. But why it is a problem for us? Because the life is that for the 4th year we have been living in Kiev, and there is a question of feasibility to have such an asset that is not used by us. For us, it is essential, and there is possibility to sell this house and some other immovable property in Ternopil and invest this fund from these sales in Kiev. We would like to buy maybe a residing object, a house or an apartment. And all the circumstances related to the construction of this house, for me personally and for our family, are emotional, because it was our dream, so we worked over it. And for a long period of time, for many years, we took a lot of efforts. I personally participated in the construction. My father-in-law worked there, so we physically worked there. With my hands, I did something, so I put in bricks, I worked in the orchard, in the vegetable gardens, I planted the trees, and I have started to do a lot of things. And for me, I'm not ready to it. I don't know what will be in future. Maybe in future we will have to sell it, but now it's really... It's a pity for me to sell it, because this house for us is very important. But nobody knows. Maybe in future we will go to live there. Nobody knows when. Maybe tomorrow and maybe in some time. Or maybe we will join the consensus that we should provide for ourselves here, and we should use the opportunities we have, not to postpone it for future, but to live now. Thank you.
For your explanations, because we have a number of questions also. Now we give floor to Madam Oksana.
Дякую.
Thank you. Mr. Taras Olehovich, let's return to Ternopil. It is clear that in the year 2012, when you had bought this house, in the same house you bought a plot of land on which there was this. So there was a sale agreement as of 8 February 2012. You acquired a land plot with cadastral number, the area 0.0179 hectares, located at the following address: Ternopil region, the city of Ternopil, Project Kolinova Street. So this land plot was bought for 6,210 Ukrainian hryvnias. Do you think that this was the market value of the land plot? Do you think that in the city of Ternopil, we understand that this is quite a well-known cottage area, there are a lot of communications and comfortable houses are built, so don't you think that it was underestimated value? Thank you. I wanted just to say that, yes, we bought it, but it was just an empty one without any non-finished constructions. Yes, I agree. So here I would like to say the following. The land plot you are talking about was part of the bigger land plot. It was land plot with the area 0.012, and it was for garden purpose, and we wanted to build a house there. That's why during negotiations with the seller we came to a consensus that we will buy this plot just if they change this purposefulness. Well, you know, negotiations were held during 6 months or something like this. The seller said, okay, yes, we were not in a hurry, it was just, you see, it was about our... Mr. Taras, so please, let's talk about the value. Yes, I'm talking about it. So, in the year 2011, this land plot, 0.012, it was related in two parts, 0.01 for housing and the rest for the gardening. So the value was for this bigger land plot where the house was constructed. And when the rest of the land plot was bought, it was not so big one, because we started to build it on the 0.01, and its price was 107,000. But in the contract it is written 6,000. No, I mean that 107,000, it was the cost of the bigger plot. But this 0.0279 hectares, it was, a complement to this bigger terrain plot that we had already bought and where we were to erect the house. So it was just about purposefulness. We didn't want to violate the law, but other people did it. For example, when people just bought a land plot for gardening and then they erected the house and then legitimated, etc. Okay, and then in the year 2018, you privatized the adjacent plot. Don't you think that in that period when you were promoted in the law enforcement organs and there is such a adjacent land plot on a free term basis? Thank you, Ms. Oksana. I will explain you. So the land plot, the land that we own in the city of Ternopil, comprises 3 land plots. The one is 10 acres, the second one is these 2 acres, and there is adjacent of 0.4 hectares. When we bought these plots, we started to use the last one, so with 0.04, and it was in the lease of the sellers. Then I became a landlord, so I just was the holder of the leased land plots. So we're talking about, you see, agglomerate of land plots, and then for 1 year and a half, I rented this land plot, and in 2018, I haven't worked at this period in law enforcement and other state bodies, so I used the right and I made this free privatization for one land that was divided into 3 different land plots as for different status, but it was limited like with our fence. So the main one is this 0.01 hectares. Okay, let's pass to the work of your prosecution office. I mean from the period 2016 to 2022. So in the year 2022, as far as I understand, your family, you and your close people, privatized 7 land plots. In 2022, 5 land plots on free basis. Is it correct? Yes, I can explain it. Explain it, please. So at first, it seems that this is too much, and maybe there are some evidence-based doubts. But to clarify these doubts, I would like to say that there are some main moments that will clarify the situation. Well, I will start with the fact where it is. All these land plots are not in Carpathians, are not in recreation area. They are 140, 150 kilometers from Carpathians. They are in the village where I was born, where I was raised. And you know, I studied my geologic tree, and I studied 5 generations. It's really very interesting, but let's talk about privatization. So in 1990s, in early 1990s, when there was the changes of different process and the use of my, so the use by my parents and at first by my grandfather, so these places, these land plots were distributed to different people. So we call them vegetable gardens. So due to the different characteristics of land and terrain, they were smaller ones. It was like the 15 acres, 20 acres. So they were smaller, but they're numerous. So they didn't come to the threshold during this period. So these land plots were used by my parents and by me before for 30 years. So it couldn't be like this. And the state encouraged to have the ownership right for terrain and land. So in 2021, the question was raised about the fact that we should have the documents of the ownership. My mother was in charge of this operation because she lives there, and as we talked about such numerous land plots, we wanted to have rights for them because they were just in the use. So there was a special administrative book where we filled in all the information. And in the year 2022, there was a decision that all these land plots will be registered, not all for my mom, but she was suggested by other people because she was said that you are not eternal and maybe it's better to register them for your children. So for me and my sister. So we could, and partially these land plots were documented. For me, two of them for me and two of them for my sister, and the land plot under the house, it was documented for my mom. So that's why we decided to do like this. So you see, there are no any doubt, as I think, that some leverages, power leverages were used. It's my motherland, it's my mother city. Yes, Mr. Taras, we are talking about this interview, to clarify all these things and debunk all the doubts. What was the purpose of these land plots we are talking? So these seven land plots. Tell us the purpose. The house we understand. What about the other land plots? Okay, so 2 land plots. These were parts. So these were field shares. It was the state act from 2008. Purpose. Tell us purpose. 2 for agrarian purpose. Other land plots. The main one under the house for residential construction. And other 4 for private village activities. How they are used today? Who uses them? As we live far and my sister lives much closer, well, the situation is like this. So I'm the owner of 2 land plots. One of them is adjacent to the house. This land plot is used by my parents. They use it for growing vegetables and agrarian cultures. So they use them for their private usage and they share their in-kind help from these vegetables. The other land plot with the 35 acres, it is a bit more remote one. It is not used actively. I mean, nothing is grown there, I would say, because there are only multi-year plants that can be used then as a mow, etc. So, and now, no other things. So it doesn't provide, any parasite plants. It is ordered, but there are no vegetables or something like this. So there are only herbs. Mown herbs are grown, and other 2 plots are used completely. So they leave 60%. So this is 40 minutes of driving, and they come each days off and work on this land. Okay, so also the advisory group has sent you an inquiry asking to provide information on land plots that your mother has. We didn't have any answers from you, but we know that your mother is entitled of the ownership in Ivano-Frankivska Oblast, in Potik Rural Council, and these land plots are currently leased to Zahid Agro MHP under long-term land lease agreement. Can you explain why you haven't provided this information from the very beginning? Thank you. Ms. Oksana, in the inquiry I have obtained was about the information about the land plots for private agrarian activity, for private village activity, I'm sorry. So answering to your inquiry, I provided you the information about these land plots. Other two land plots, they were not in the inquiry. They have other status. So they are for product and agrarian use. So these are like land shares. So they are transferred in lease to this society that you mentioned. So they work on this land plot. They grow something and they give us grain. So these land plots, these are 7 privatized or not? These are separate. No, these are separate. When in 2008 the 2 state acts were provided for the right of ownership for these 2 land plots for agrarian production. It's not for private agrarian activity. These are for production. Thank you.
Now we are from the land, we are going back to the apartment and money. And you know, we have noted that your son, Nazar Tsymbalist, purchased an apartment with a total area of 66.9 square meters at the price of 2 million, I think, yes, it's 2,194,116 Ukrainian hryvnia, located in Demivsky Lane, Kiev. On 2nd of August 2022. According to your statements and the documents provided to the advisory group of experts upon request, it appears that the purchase of this apartment was funded by monetary gifts from you and your spouse, as well as your son's personal funds. Specifically, you gifted 1,760,000 Ukrainian hryvnia, and your spouse gifted 574,000 Ukrainian hryvnia, totaling 2,334,000 Ukrainian hryvnia for the purpose of your son's apartment purchase. Consequently, you and your spouse gifted your son nearly 140,000 Ukrainian hryvnia more than the cost of the apartment. Please explain why you gifted your son an amount exceeding the cost of the apartment, especially considering your assertion that your son had his own savings for the purchase. What was the reason that you gave him such amount of money, yes? Extra money, we can say.
Thank you, Ms. Hanna. It will be my pleasure to answer your question. The apartment we bought, I say we, as members of the family, because my son Nazar, he's 20 years old, and he has always been the member of our family. Now I show him as member of our family, because he is. So the sum was greater, because this apartment was not ready to live in. This apartment needed repair works, and for repair works we had to foresee any funds, because for the previous dwelling that we rented, it had to finish on the 5th of September, and we bought it on the 2nd of August. So you see, we have less than a month to do everything, to provide this repair. So these funds were foreseen not just for a purchase, but also to finish and to repair this apartment, than to have possibility to live in, because we had to move in a very fast way and to use this place. That's why the sum was bigger.
It's for you, but sometimes, because as we received the information,
Немає перекладу.
does it work? Something happened? Yes, maybe that now work. Could you hear me?
Він є синій колір.
Maybe no. Maybe it was a break. I don't know. So something. Now you can hear me. I hope.
Дякую. Так.
So now
Так, чую, дякую.
following the same question, yes,
Дякую.
but we are trying to enter deeper to some details. And you explain us that you gave the extra money for your son because the apartment needed repairs work, yes, so for that reason it was needed. But as we received the information, the amount gifted by you and your spouse to your son effectively represents all the official savings and income of your family. So you gave him everything. Furthermore, it appears that you had to even resort to borrowing from individuals. It was true. And could you explain whether such risky financial behavior by your family during these unstable times raise reasonable doubts about the existence of other undisclosed assets or sources of income? Because exactly you said that there were needed reparations, I can say, yes, to bring the apartment and for being to be lived there. But you decided to give exactly such a huge amount of money in such an unstable period, borrowing money. How is your explanation concerning this situation?
Yes, I can explain it. Thank you. Thank you for your question. With great pleasure, I will explain you the situation about the purchase of such object. So, purchase of such an apartment, in that case, this is transaction that is not done each year. I mean, here we just took all the funds that we had for this, because as a very expensive purchase, we did our best. We involved all our funds, but not to give you an impression that here are some doubts or something like this. All these funds that we donated to our son, these were all that we had to give for this transaction, for implementation of this transaction, I would say. So we didn't have enough money. That's why we addressed our friends and we asked them to borrow some funds. And I addressed to bank, and my wife also went to bank, and we accumulated all these funds, and then we donated them to our son for this purpose. Yes. Yes, it was a risk, I understand. But we were aware of this risk, because living since summer 2020 in Kyiv without our own housing and giving a lot of money for renting apartment and not living in our own apartment. So we thought that it's not a normal situation, and we just created the conditions to live for our family. So it's a temporary, but yes, this was the resolution for us.
Sometimes for me it's not very clear, because we also discussed in the beginning of our talk today that you also borrow money, 120 from one friend, 120,000 from another friend, and now you borrow money for helping your son. It is always the same amount of money or different borrowing. How you can explain? Yes, because it's your custom to borrow money from friends for everything what we are doing. Or, I don't know. Yes, could you explain us how it is your custom?
Thank you. With great pleasure, I will explain. Now, it's not our custom to borrow money. It's only in some extreme situation. And these borrowings that were stated from these people and the loans from bank, they had only one purpose: to accumulate the sum, to add to the sum that we had, to have the relevant sum to buy an apartment. That's why I borrowed this money, these funds, because my son now, he doesn't have income, he doesn't earn money, he doesn't have some social links in Kiev, and he cannot involve these funds. So for me it was easier to do, and that's why I used this opportunity, and I transferred these funds together with my money to my son, and it was very obvious.
I think that maybe later we'll come back because we have some more questions. Ms. Oksana also.
Дякую. Тарас Олегович.
Thank you. Taras Olehovich, you participated So you took part in an open competition to select candidates for the position of prosecutors of a specialized anti-corruption prosecutor's office. You successfully passed the first 2 stages of the competition, but you informed that you stopped participation of the competition for the specialized anti-corruption prosecutor's office upon your initiative. The reason for this decision was analysis of interviews held on other candidates. You got the impression that the position of the selection committee was the only person who experienced in pretrial investigation could be appointed to a position of a prosecutor in the specialized anti-corruption prosecutor's office, and you didn't have such experience. In addition, can you explain, do you have any background for the position of this competition for the Constitutional Court? Thank you. Thank you. It will give me the possibility to reveal my motivation. Yes, in 2020, I participated at the same time in 2 different contests. It was for Specialized Anti-Corruption Prosecutor's Office and General Prosecutor's Office. As I have stated, they were under the reform of Prosecutor's Office. It was a large-scale reform and staff change, and I decided to take part in this selection procedure. I succeeded in the General Prosecutor's Office, and as for the contest to the Specialized Anti-Corruption Prosecutor's Office, it was almost in the parallel, but it was 1 week late for all the stage. And for Specialized Anti-Corruption Prosecutor's Office, I had even much better results than for the General Prosecutor's Office. But at the time of interview, I have already been appointed for the General Prosecutor's Office. So I took a decision that I have already appointed, and there is no need for me to be involved and to be appointed in the Specialized Anti-Corruption Prosecutor's Office, because I have already achieved my desire, my dream. And I obtained quite a good result, and after it, I started to work in the General Prosecutor's Office. So, yes, it was... As for what you have said, yes, it was my impression, but it was about the relevant experience properly in pre-trial investigation. When we talk about the Constitutional Court, this is quite another story, because my interest here, the problems, the issues of the constitutional contract, jurisdiction, and justice, it's from very long story. So I was graduated from Lviv Ivano-Franka University in 1997, and my graduation work was about the Constitutional Court. I planned to enter the postgraduate program, and my topic, agreed with my scientific advisor, was the law defense of the Constitution. Petro Bogdanovich Stetsuk was my scientific advisor of my university thesis and then PhD thesis. But this topic was given for my colleague, and it was successfully implemented. And after my interest towards the constitutional jurisdiction grew and went in depth, because I was a lecturer of the relevant course. Most my articles are related to the constitutional justice. I was the author of the first manual of the constitutional justice, so this was the main topic for my scientific research. That's why this interest I had constantly. In the year 2017, submitted document for a selection procedure for the Constitutional Court of Ukraine, and that's why I presented my declaration for 2016. And all my research, all my further research, they were related to this issue. That's why it was relevant for me. It is my dream. It is my opportunity to get involved into some state creation, state implementation problems. It gives me the possibility to use my knowledge, to use my skills for the benefit of the state. And this is the reason, this is my motivation for this position of a judge of the Constitutional Court. It just happened that since 2020, I have changed the profile of my activity, and for 3 years, more than 30 years, I have been working for the General Prosecutor's Office as a prosecutor. But all my previous background, all my previous professional life after the graduation from the university was related to the pedagogical and scientific activity and research activity. And the main topic of this activity was the problem of constitutional jurisdiction. Mr. Taras Olekhovich, again, now you participate in two different contests. For the Constitutional Court and for the Judge of Constitutional Court and for the position of judge. Due to your motivational letters, I mean for a selection procedure of a judge of general jurisdiction and for Constitutional Court, it is written that I believe that I correspond to all the relevant background, etc. So there are a lot of things that are really very similar in these both motivation letters. So just in one letter it is mentioned Constitutional Court, in other just court. Can you tell us what is the difference between the general judge and judge of the Constitutional Court? So your personal point of view. Do you see any difference? Sure, there is very global difference because status of Constitutional Court and of a judge of Constitutional Court, it was different even before. But after the relevant amendments to the legislation, it has become even more different, because before, under the legislation and constitution, Constitutional Court was a part of the judicial part, and now it is not. It is quite another state body with another vocation, with another destination, I would say. That's why nomination my candidacy to both selection has explanation. Explanation is very easy. The selection procedure for the court of the Constitutional Court of the judge of the Constitutional Court was announced before, and it was my priority. After the appellate court selection procedure was announced, and the situation is that since 2016, when the amendments to the Constitution were adopted, when there was about judicial reform, when there was the Supreme Court, and when the doors were open for scientists and lawyers to become judges, even then I had ideas maybe to try myself in the sphere of judicial power. And after the transition to the General Prosecutor's Office, I also represent the interest of the state in the Supreme Court, in the Cassation Court, in the composition of the Supreme Court, and in my desire to implement myself, to realize myself in the in this part, just grew. And as I have known about such a selection procedure without having any confidence, I would say that it will last very short, because you see that the previous contests for general judges lasted 7 years. So I decided to use my right, but my top priority is the judge for the Constitutional Court. Thank you. I have no other questions.
The time is going on very quickly. Last questions, but we have to clarify the situation. Your wife, Tsymbalistyi, I don't remember the name, is employed as the chief specialist of the Department of Business, Accounting and Reporting of the Department of Planning and Financial Activity, Business Accounting of the Office of the Prosecutor General. She has been holding this position since 24th of May 2022, and she was appointed to the position by the order of the Prosecutor General as of 20th of May 2022. Following the procedure of transfer from the National Commission on the State Language Standards. That is, this appointment was made without an open competition. Explain us whether an outside observer might get the impression that you tolerate a kind of nepotism if your wife, Tsymbalistyi, was appointed chief specialist of this department in the Prosecutor General Office at the time when you were already employed at the Office of the Prosecutor General, because it's only coincidence of dates, or we can call it a kind of nepotism. Please, we need your explanation.
Дякую.
Thank you, Ms. Hanna. Directly answering your question, I would say that this is just a coincidence, and more in detail, I will explain my position like that. After I moved to Kiev, in 1 month and a half, all my family moved here, because it was the starting of the academic year, and we had to decide whether we live in 2 different cities or we live in 1 city. So my wife quit from her work, and she with children lived here. And at the beginning, she didn't have any work in Kiev. In some months, she found employment. It wasn't as for her education, but she decided to work in Kiev Regional Prosecutor's Office. It was in the Stationary General Department. It wasn't qualified. It was just a temporary employment, just to have possibility to earn money and to live in Kiev with the whole family. Some period later, my wife participated in the selection procedure for the chief accountant at the National Commission on the State Language Standards, and she worked there for a year. After the circumstances changed, it was related to the fact that when my wife worked for the regional prosecutor office, she worked in stationary department, in general one, but everybody knew that she was an accountant, and they consulted the accounting office, and she was perceived not as a person who registers input and output correspondence and letters, but she was perceived as accountant, and she expressed the desire that my wife was transferred to there, but there was no vacancy. Sometime later, after my wife worked in the National Commission, yes, she communicated with her ex-colleagues, and so they said that, you remember we talked about the fact that we wanted you to work for us, and the colleague said that there is a vacancy in the Office of Prosecutor General, and they need really a very good specialist, not a newly graduated one. So my wife was very critical about it, but then she was very serious. She met the head of the department, and she said that it was okay about the conditions, and the head of the department said that it is okay with her qualification, and it was their consensus. So I'm not, there is no my attitude towards it. We just work in one establishment, but we even have offices in different places. So today it is like this. I don't know how it will be in future. Maybe she will pass to some other departments or to some other places. Maybe she would like to implement her functions somewhere else. So I'm not contributing to her background. Are there any questions? Please, Ms. Marek Subik.
As allows me, I would like to ask you more general question. Aleś, may I?
Yes, yes, please proceed.
Dear Taras Olechowicz, I find out in your biography the title of your dissertation, Constitutional Legal Status of the State Border of Ukraine. May you present us very briefly 2 or 3 main theses of your dissertation?
З радістю.
With great pleasure, thank you, Mr. Marek, for such an opportunity. As I have stated, after graduation from the university, I planned to have another topic. I wanted to have the legal defense of the Constitution, but because of the fact that after graduation of the university, I was distributed to Khmelnytska Academy of the Border Guards, so my scientific research for the PhD program in law, under the conditions I had to work in this specific of this academy. It was Academy of Border Guards. That's why the topic I wanted to work on, it was put aside and I was forced to work on it. It was constitutional and law status of the state border of Ukraine. Main thesis. So, main status, please. Main statements about my dissertation. My dissertation was just the plan. Can you voice the plan? What was the plan of the dissertation? As far as I remember, there were 2 sections. The first one, the historic and theoretical background of the constitutional and legal state border. At first, it was about the history and development of this legal institution, and then there were theoretical statements that provide evidence-based approach for its structure. And the second section was dedicated to the regime of the state border. So, I mean, the regulation of the issues of usage of state border. These were different regimes. These were the state border regime, these were cross-border regime, and near-border regime. I analyzed all these stages. It was really very interesting for me, for the management of the establishment, the educational establishment I worked, because it was really very useful. At that period, these regulations were different, so the border guards forces there were, and I provided some grounds that it shouldn't be military structure. It should have been civil character. That's why I grounded the reorganization of this state border service, and I also input some draft law about this state border service, and I hope that all my dissertation helped and contributed to the reform that took place after. And that's why I think that I managed to implement all my visions, all my theoretical works in this regard.
Є ще запитання?
Are there any other questions? Mr. Vasil Ivanovich, as member of the AGE of the experts, please answer the question from my deputy. You know, I would like to say that you exaggerate a bit that your dissertation was the ground for reform, because frankly speaking, I have published 15 years ago a book about the concept of it. And also, I talked there about this state border reform. But the question is not in this. You know that lately CensorNet published this survey of citizens about the trust towards state power. And there were about prosecutor office, and there were some positions stated that a bit less than 10% of population believe and trust to the prosecutor's office. How do you think, with such a background, how can you like reform the constitutional court with such a background of trust? This is the first question. And also, you said that when you donated money to your son, you said that your wife went and took from her bank account, took some money and transferred. And in the agency where she worked, I think related to the language, I don't think that she earned a remuneration that permitted her to give in gift such money. Or it was your error, maybe you have mistaken, or something goes wrong. Okay, so I will address the first question. I don't say that my dissertation led to this reform. I hope. Okay, the question about the trust. 10% of population believe to prosecutor's office. How do you think with such a level of trust to reform the constitutional court? You see, well, I don't think that working prosecutor's office can discredit myself. You know, I came to the prosecutor's office in 2020, new prosecutor's office. So it's just a 3 year that I have been working there. I understand that there is mistrust to the state bodies and to the prosecutor's office that you have stated take place. But maybe it is a systemic problem. Maybe it's not about the level of trust only to the prosecutor's office. And the second thing, that the reforms and measures taken in September 2019 and implemented in 2020-2021, I think they enhanced and improved the situation, that through the staff reloading, the situation changed. Maybe not drastically, maybe it could have changed more, but I think that changes were there. So there was a selection procedure under which only 70 people became prosecutors of the office of the prosecutor. It is a few, it's just a drip in a sea. But I think that this is one stage. Okay, Mr. Taras Olegovich, we have timeline. The second question was about the money your wife gave to your son. Yes, my wife donated 574,000 hryvnias to the son. These funds were at my wife's. Not only she took it from her account, so these were her funds together with my funds accumulated with this purpose. So my declaration, my excerpts from declaration I declared all the incomes. I have a table for my wife. Also, I have a special table, pre-tax, after-tax, with the dollar equivalent, and all these figures give us possibility to say, I'm sorry, the situation is the following. You said that you gave a sum and the other sum was given by your wife. So you said she took from her account. I'm sorry, can I clarify? Yes, we see, so please don't clarify, we see it. So bigger part was mine. Are there any other questions? If not, before wrapping up, please, Taras Olegovich, you are given the opportunity with your closing statement for the AG members and for members of public with your closing remark. Please take the floor. Dear members of the advisory group of experts, dear deputies of the AG, it is a big honor for me to participate in this selection procedure. As I have already stated, during quite a long period, the activity I have done created a basics and foundation for motives that pushed me to participate into this selection procedure. I wanted to express my gratitude to you, that you were tolerant, that you asked me question, that you gave me possibility to pay my attention to the moments that were not so obvious for the external observer, and I hope that I clarified it in my answers. Also, I would like to express my separate gratitude to you for the time and for activity and for your attention in the framework of this competition, because I think that such an open competition is really very necessary for the rule of law in Ukraine, for the restoration and recovery of trust towards state bodies, towards the constitutional court from the ordinary people. So maybe it's very difficult emotionally, because sometimes there is need to debunk some evident, I would like, questions, but this election procedure gives us possibility to find out who is the best in different aspects, in moral aspects, to find out people who correspond to the high value. And, for example, there are parallel contests like in different selection procedures in different spheres. We can find out people who are not integral, people who do not correspond. So I think it is really very right thing. It will able to recover the trust towards the state and towards the Constitutional Court of Ukraine. That's why I do hope that I managed to answer your question, and I do hope that I managed to clarify any doubts that you could have, or maybe external observer could have. I hope that my position is understandable by you and you understand my motivation. So thank you for your attention. I wish you successful competition, and I wish us fast prosperity, fast victory, and prosperity of Ukraine. Thank you, Taras Olegovich, for your questions, for your answers. The AG now closes the interview with Tsymbalistyi Taras Olegovich. Thank you.